Welcome everyone to this Center for Transnational Law book talk event sponsored by the Center for Security, Race and Rights. We are very pleased to have Professor Hedy Viterbo with us today to talk about his magnificent book, Problematizing Law, Rights and Childhood in Israel-Palestine, which is going to be followed by two discussions by Noura, Erakat, and by Sarada, Balagopalan. I'm going to introduce our three panelists, and then I'll give the floor to Hedy right away. So Hedy Viterbo is a professor, a senior lecturer in law at Queen Mary University of London. Previously, he was lecturer in law at the University of Essex, a Leverhulme Early Career Fellow at SOAS University of London, a visiting scholar at Harvard Law School, and a visiting researcher at Columbia University. He received his PhD in law from the London School of Economics and his LLM from Tel Aviv University. His research examines legal issues concerning childhood, state violence, and sexuality from an interdisciplinary and global perspective. As I said, after Hedy's presentation, we will have comments first by Noura Erakat, who is a human rights attorney and an associate professor at Rutgers University in the Department of Africana Studies and the program in criminal justice. Her research interests include human rights law, humanitarian law, national security law, refugee law, social justice, and critical race theory. Noura is an editorial committee member of the Journal for Palestine Studies and a co-founding editor of Jadaliyya, an electronic magazine on the Middle East that combines scholarly expertise and local knowledge. She's the author of Justice for Some, Law, and The Question of Palestine, published by Stanford University Press in 2019. And then we'll have comments by Sarada Balagopalan, who is an associate professor of childhood studies department here at Rutgers University. Her interdisciplinary research engages marginal children's experiences with compulsory schooling, labor, gender school spaces, children's rights discourses, and pedagogies of citizenship. She is trained in education and anthropology, and her work is directed both at challenging the exclusionary logics that often underline humanist efforts around marginal children, as well as productively drawing upon these children's lives to decenter hegemonic assumptions around childhood. She's the author of Inhabiting Childhood, Children, Work, and Schooling in Post-Colonial India, published in 2014 by Palgrave. Without further ado, I want to give the floor to the author, Hedy Viterbo. The floor is yours, Hedy.
Thank you so much, Jorge, not just for moderating, but also for organizing this event so flawlessly. A couple of thanks also to the Center for Transnational Law for hosting us online today, to the Center for Security, Race and Rights for co-sponsoring, and many, many thanks to Noura and Sarada for participating, and I really look forward to hearing your insights soon. So I'll start by outlining what the book tries to do, and it basically offers a rethinking of the relationship between state violence, law, human rights, and childhood. And even though the book focuses on Israel-Palestine, it also tries to provide broader insight. And it also draws parallels and connections with some other times and places. The findings of the book are based on hundreds of sources that I've analyzed over the last 14 years. Almost none of these sources have been examined before, and many of them are not publicly available. In terms of the theoretical framework, the book takes an interdisciplinary approach. It brings together several bodies of knowledge, including critical legal theory, critical childhood studies, and critical literature on human rights. And one of the exciting things about today's panel is that it reflects these different fields of scholarship. And I'm sure our audience is also quite diverse in terms of areas of expertise and also in terms of familiarity with the issues we'll be discussing. So one of my aims when writing the book was to make it as accessible, relevant, and interesting as possible to a broad readership. And the first two chapters in the book, there are 8 chapters overall, the first 2 chapters lay the necessary foundations theoretically, legally, and geopolitically. I should also note at the beginning that the focus of the book on childhood is important in two different respects. First of all, if we define a child as anyone under the age of 18, which is what the UN Convention on the Rights of the Child does, then half of the population in Palestine is children. But there's a second reason for the focus on childhood. As the book shows, discourses and practices that seem to focus on children are actually no less concerned with adults. And these aren't only adults that have direct responsibility for children, such as parents, teachers, or social workers who are, quote unquote, the usual suspects. These adults also include others, such as Palestinian adults in Israeli prisons, or Palestinian adults who are killed by Israeli airstrikes, or Israeli soldiers who are formally adults but are often conceptualized in Israel as children. And I'll say a bit more about this soon. Now, in terms of the main arguments of the book, let me just mention a couple. One key argument is that Israel doesn't simply disregard international law and human rights. Instead, Israel has been pursuing a much more sophisticated course of action. It's been increasingly using law and human rights to perfect, conceal, and legitimize its violence against Palestinians. And there's a growing body of scholarship about the complicity of law and human rights in state violence, not only in the context of Israel-Palestine. For example, in some of my own work, I've written about how the US and Israel and some other countries use legal arguments and instruments to justify and hide their use of torture. And I've also written about how the US and Israel adopt each other's legal arguments in order to legitimize their own actions. Other scholars, including Noura, have also written about this theme, especially in relation to Palestine. And if you're not already familiar with Noura's work, you should definitely check it out. At the same time, the existing literature has some major gaps and blind spots. And one of them has to do with child rights and with childhood as an identity category more broadly. So critical legal scholars often have a sophisticated understanding of other identity categories, such as race, gender, sexuality, and disability. But when it comes to childhood, these scholars tend to express views that are uncritical, simplistic, and crucially, insensitive to the specific socio-political context in question. So as I've mentioned, the book brings critical scholarship on law and human rights into dialogue with childhood studies, such as Sarada's work and the work of many other childhood scholars. So the book lays bare how law and human rights don't simply regulate or respond to pre-existing children and adults. Instead, discourses and practices of law and human rights are heavily implicated in the social production of childhood and adulthood as categories. So these discourses and practices manufacture childhood, they reinforce it, they negotiate it, or they challenge it, and they also weaponize it in multiple ways. So as I've noted, academic and public criticisms of Israel are often based on simplistic, romanticized, and problematic views about childhood. For example, Israel is often described as, quote unquote, robbing Palestinians of their childhood. Another common narrative is that the young people we define as children are naturally and universally different from those we define as adults. And these alleged age differences are then said to require special treatment, which Israel is accused of failing to provide. Another claim we sometimes hear is that childhood itself is a right, or in other words, that Israel is denying Palestinians their quote unquote right to childhood. But the book shows how Israel doesn't simply deny childhood and children's rights. Instead, it's been increasingly imposing on Palestinians a legally enshrined childhood. And this childhood works to the detriment of Palestinians, and it's also partly based on international standards of law and human rights. So throughout the book, there are many revelations about how childhood and child rights operates as tools of oppression and domination. One example, which is discussed in chapter 4, is a series of reforms that Israel introduced in the last 2 decades. So one reform was the separation of Palestinian children and adults in Israeli prisons. Another reform was the creation of what Israel calls military youth courts. These are courts that try young Palestinians separately from their adult counterparts. So these reforms were advocated by the human rights community for many years in the name of children's rights and international law. Eventually, Israel implemented them, and now it repeatedly cites them for PR purposes. But the book shows how these reforms have actually harmed Palestinians in multiple ways, and I'm happy to say more about this if anyone's interested later. In some of my previous work, I also exposed parallels and connections with the treatment of children in other settler colonial societies. So one long piece I published a few years ago compared Israel's policies to the way in which indigenous children have been treated in the US, Canada, and Australia. And the book builds on this earlier work while also trying to develop it further. So I've explained why childhood is a blind spot or a gap in the existing literature on law and human rights in Israel-Palestine. But there's another gap, which is the failure of scholars to examine the legal institutions and actors on the ground. Instead, what actors have been focusing on is either international law or the Israeli Supreme Court. And even though this new book does deal with these legal arenas, it also tries to go much further. So for example, this is the first academic book ever that examines Israeli military judgments. Now, military courts are a huge part of the Israeli legal system because every year, Israel prosecutes thousands of Palestinians in these courts, including hundreds of children. In addition to trials of Palestinians in these military courts, the book is also the first to analyze trials of Israeli soldiers in courts martial. And it's also the first to examine trials of Israeli settlers in civil courts. So what the book tries to do is to expose for the first time how law and human rights shape people's lives, not only in international forums or in the High Court, but also on the ground. At the same time, Israeli courts are only one of the sites that the book examines. It also covers various other actors and issues. So for example, it deals with issues relating to preemptive technologies, surveillance, torture, and the use of human shields. It sheds new light on the travel restrictions that Israel places on Palestinians, and it offers new insights on the Israeli closure of the Gaza Strip. So as you can see, the book is highly critical of Israel, but it also criticizes the dominant language and mechanisms of human rights. It reveals how they promote ideas and agendas that are conceptually limited, factually inaccurate, and politically problematic. In many ways, the dominant framework of children's rights is harmful to the Palestinian children that it claims to serve. It exposes them to greater harms, it empowers them, and it also, as I show in the book, it also misrepresents and even ignores their voices repeatedly. But as I've alluded to earlier, the children's rights discourse also harms Palestinian adults because it legitimizes apathy and even punitiveness towards these adults, especially if they're Muslim men. So the book demonstrates how the human rights community is implicated in all of these issues, and this includes NGOs, both local and international, UN bodies, and some scholars who write on Palestinian children. The book also shows how some human rights organizations describe Palestinians as a potential security threat. And in this way, they reinforce the Israeli security discourse. But the book doesn't only deal with the state and with the human rights community. It also brings to light various forms of resistance by ordinary people. So, for example, it examines cases in which Palestinian adults were able to trick Israeli authorities into thinking they were actually children. In this way, the performance of childhood and age could be used not only as a tool of state control, but also as a means of resistance. Another form of resistance that's discussed in the book is the way in which Palestinians try to pass political knowledge from one generation to another, both within and outside Israeli prisons. And these are just a couple of examples of the sort of political resistance that's highlighted throughout the book. So there are many other issues I could mention, but I'll stop here. Noura and Sarada, I look forward to hearing your thoughts, and many thanks for listening.
Thank you very much, Hedy, particularly for giving us a little more time to address some of the many interesting and fascinating aspects that your book addresses. Noura, the floor is yours.
Thank you, Hedy. You know, listening to you again, I'm struck a second time upon reading and now upon listening how provocative your intervention is and how much you're attempting to disrupt what it is we know and even our modes of advocacy. So I'm going to read my comments for the sake of time. Professor Hedy Viterbo's book adds to a growing literature regarding the detrimental role of law in protecting Palestinians and advancing their cause for freedom more generally. Despite the fact that Israel has launched acerbic campaigns targeting human rights actors and international tribunals, as indicated by its accusations of anti-Semitism against the ICC, its withdrawal from the Human Rights Council, its deportation of the Human Rights Watch Israel-Palestine director, Omar Shaked, its denial of entry to the UN Special Rapporteur on the occupied Palestinian territories, Richard Falk, as well as its recent designation of 6 human rights NGOs as terrorist organizations. In fact, the law has done little to protect Palestinians at all, and more, Israel has used it far more strategically to advance its settler colonial interests. These conditions have prompted practitioners and scholars alike to ask, to what end then is the value of the law, and what work is it in fact doing? Hedy answers this question in particular regard to the rights of the child, mostly Palestinian, but Israeli as well, a worthwhile side of inquiry as the rights of Palestinian children lend themselves to obvious critique when, until recently, the age of majority of Palestinian children was 16, in contrast to Israeli children who reach that age at 18, when Palestinian children as young as 5 years old are detained, and when children as young as 12 are tried before military tribunals without the participation of their parents, without adequate legal counsel, and often without translations of legal documents from Hebrew into their native Arabic tongue. Worse, Palestinian children are also extrajudicially assassinated during protests, as was the case in the Gaza March of Return, or as idle bystanders, along with the rest of their families in their homes, as was the case in Israel's most recent aerial offensive against the besieged Gaza Strip in May 2021. There is literally no refuge for Palestinian children who in common public imagination claim the mantle of innocence. So egregious are these conditions that US Congresswoman Betty McCollum has introduced legislation that boldly seeks to restrict US aid to Israel so that none of it can be used for purposes of harming Palestinian children. Notwithstanding these conditions, or perhaps precisely because of them, Hedy concludes that, quote, law and rights have thus aided Israel in its effort to subjugate Palestinian minds, bodies, and interactions. And his critique equally scrutinizes the state for its violence, as well as the human rights community for its advocacy. Using a unique method of combing through 155 Israeli military court files, Hedy also notes the military documents do not reflect a particular reality, but rather provide insight on their symbolic and material effects. He explains that they shed light on stories, quote, about themselves and the world in which they operate, and speaks as much through their omissions to provide a window into a self-perception rather than the empirical evidence of an event or a phenomenon. In addition to offering a damning critique of hyperlegality, Hedy also disrupts legal distinctions between children and adults, as well as between children and soldiers, thus making radical and ostensibly controversial claims among not merely legal advocates, but human rights communities more generally, for whom these distinctions constitute a foundation of their critique and more broadly of their worldview. So now with the rest of my time, I'd like to make 4 observations based on Hedy's provocations, and we'll conclude with questions for him. The first is on the outright dehumanization and securitization of youth. And so I'll draw on my personal experience. When I was an undergraduate student in California, this was at the height of what's known as the second Palestinian Intifada. Senator Dianne Feinstein explained that the killing of Palestinian children was a reflection of improper motherhood. In particular, she suggested that Palestinian mothers just don't love their children enough to protect them, thus fitting into the racial trope that Palestinian parents hate Israelis more than they love their children. This gender discourse escalated when in 2014, then Justice Minister Ayelet Shaked suggested that Palestinian mothers birth snakes, thus explicitly weaponizing Palestinian wombs and reproduction. The thorough dehumanization of Palestinians through a security discourse is so aggressive that Palestinians almost never appear as victims. Even in gestation or infancy, Palestinians are a threat, or at least a suggestion of a threat of an attack on Jewish life. As Hedy notes, today, 96% of security prisoners are Palestinian, 0.2% are Israelis, and the rest are Arab foreign nationals. I offer that this reflects a settler anxiety. Israel's securitization of Palestinian natives reflects a settler anxiety that has equated its settler sovereignty with a Jewish demographic balance and has driven a policy of racial purity. The native population, like the ones Hedy cited in North America, is securitized precisely because mere markers of native belonging threaten Israel's settler sovereignty. It is not then paranoia about what Palestinians may do to Israelis, but the fact that Palestinians threaten to stay and to assert their belonging. Militarized state violence, whether in the wholesale destruction of Palestinian villages, killing or expulsion of Palestinian natives through other means legalized by the Israeli state, is an essential vehicle through which colonial expansion is actually actualized and fomented. Palestinian youth, therefore, are already a threat or would-be threats should they be allowed to age. This helps better understand Hedy's pointed observation that Palestinian youth is actually an aggravating rather than a mitigating factor in court proceedings that, quote, seeks to punish the young and discipline the elders. Now, this, of course, is somewhat in contrast to the international conception of Palestinian youth, which does ascribe to them an innocence their elders cannot claim. And this brings me to my second point, which is the short-sighted and counterproductive use of young Palestinians to critique Israel. In a recent interview I conducted with Palestinian poet, writer, and activist Mohammed al-Kurd, who has come into international prominence because of his remarkable advocacy on behalf of his family and his home in Sheikh Jarrah, really on behalf of all Palestinians, I asked him about the responsibility of sharing the story of Palestinians from such a young age. He began to come into the public spotlight since he was 11 years old. He responded, quote, I think being a charming 11-year-old and being in a documentary and being 14 years old and speaking at the European Parliament, I think this is an era that we need to exit. There's no reason for us to be burdening our children with the responsibility of persuading American and European audiences, politicians and diplomats, just because they are too racist to sit at the table with a Palestinian adult whose razor-sharp critiques could potentially offend said politician for their complicity in the Israeli occupation. The question is both about the burden of that responsibility, but as his answer demonstrates, it goes to the heart of Hedy's critique that the claim of innocence for Palestinian youth or women or children works to reinforce the villainization and presumed culpability of adults in general, and particularly of the adult Muslim men he cites. This is a very similar to the critique Professor Maya Mikdashi has made in her piercing article that asks, can Muslim men be victims too? In the insistence on youthful innocence, Palestinian culpability is the norm and youth becomes the exception, which is quite dehumanizing, as the norm should be in the inverse, which is a universal innocence with the possible exceptions. Third, and this I found very interesting because of my own work on the infantilization of Israeli soldier, Hedy highlights how, in contrast to Palestinian children who are securitized, Israeli soldiers of majority age are infantilized, often described as children in need of greater protection. Indeed, this condition, wrought not least by the mandatory conscription of Israelis, has created even more harm to Palestinians. In 2003, and in the midst of the Intifada, the Israeli army sought to update its military doctrine and recruited Asa Kasher, professor of professional ethics at Tel Aviv University, and Amos Yadlin, major general of the Israeli army and the head of its military intelligence, to lead an ethics committee comprised of military personnel. In 2005, they proposed revising the scope of force protection that would make the lives of a belligerent state soldiers worth more than the lives of enemy civilians. Now, mind you, this is majorly radical. The idea is that soldiers, because they have the right to kill, are trained, they're not accused of murder, right? That their lives are obviously worth less than the lives of their own civilian population, but also the enemy civilian population when trying to determine military advantage and proportionality assessments. But this flip of force protection would make the lives of Palestinians, civilians, worth less than the lives of Israeli soldiers, so that now a military general had more incentive to protect the Israeli soldier rather than to protect the civilian. How do they justify it? They explain, quote, a combatant is a citizen in uniform. In Israel, quite often he is a conscript or on reserve duty. His blood is as red and thick of that of citizens who are not in uniform. His life is as precious as the life of anyone else. The fact that persons involved in terror are depicted as non-combatants, not even civilians, is not a reason for jeopardizing the combatant's life in their pursuit. So again, as I said, this proposition unduly shifts the risk of warfare from soldiers to enemy civilians in its calculus of proportionality, thus tolerating greater numbers of civilian deaths and injuries, so long as that spares its soldiers from harm. The outcome of this almost definitely ensures devastating results for the sake of preserving soldiers' lives, such as shooting at a distance, a lack of precision, dropping one-ton bombs, right? Anything that will keep the soldier out of the field, but enable them to continue to kill. And this is a condition we have repeatedly witnessed in Gaza, as well as in the many examples of violence shared throughout Hedy's book. My final point, number 4, is about Hedy's critique of hyperlegality. One of the greatest oversights of the advocacy community is not a lack of law, but really a lack of questioning whose law. And this is drawing on Marty Koskiniemi's critique, right? So far from lawlessness, Israel has prided itself on hyperlegality. In 1982, former Israeli Supreme Court Justice Meir Shamgar boasted that Israel's governance of the West Bank and Gaza applied the norms of international law, quote, more extensively and more diversely than most, if not all, military administrations in this century, with regard to both the frequency and intensity of the application of these norms and the duration of time which passed since it was first established. For Palestinians, the issue has not been about an absence of legal norms. Hedy highlights this in his discussion of the 2011 amendment that increased the age of majority to 18 and created a separate juvenile court. As he notes, Israel easily availed itself of available loopholes in the law, like insisting that the tribunal cannot inform family of charges against the child because of a national security risk, or that a child's trial cannot be public and covered by the media in order to protect the child's well-being. This reflects a pattern, as the 1999 prohibition on the use of torture by the Israeli Supreme Court demonstrates. Not only did torture continue under the pretense of a national security exception, but note that between 1999 and 2019, not a single of over 1,000 complaints has led to even one criminal investigation to be opened against an interrogator, let alone a trial, a conviction, or punishment. The Israeli Supreme Court thus effectively provided impunity for torture in its prohibition in what was deemed a landmark decision. So here I end with a few questions for Hedy of what this raises for us to think about, right? This is a very damning, a very compelling critique. So what's to be done? So Hedy, is anything to be gained from using law on behalf of protecting Palestinians? 1. 2, in general, do you think all international human rights instruments are flawed because they are drafted also as exceptions, right? All of our human rights instruments are drafted as exceptions to a norm of some able-bodied, strong person who's endowed with racial, gendered, citizenship privilege, right? And they highlight the acute vulnerability of certain groups like children, but also racial minorities, women, persons with disabilities, and migrants. So are all of them flawed in the same way for creating this exception and this bifurcation that you critique in the distinction, for example, between child and adult. And finally, I was left wondering throughout the text, what do Palestinians say and think about your critique, especially as some of the most significant and leading activists, advocates for Palestinian children are Palestinian organizations? Thank you.
Thank you very much, Noura. It was excellent, and also excellent management of time, which I'm glad to now give the floor to Sarada.
Thank you. I'm also going to be reading from a text for the sake of time. So thank you so much for inviting me to discuss this important and rich book. Problematizing Law, Rights, and Childhood in Israel-Palestine provocatively opens up the well-known relationship between state violence and the abuse of rights by problematizing two assumptions that we've held to be quite sacrosanct in this relationship with regards to the child. The first of these is that children, given their ontological vulnerability, need to serve as a special case in efforts to foreground rights violations. And second is the self-evidence of the ameliorative work undertaken by human rights organizations. The double inversion of these well-regarded truths that Hedy's book attempts is achieved through combining multiple critical framings, including childhood studies, with his painstaking assembling and analysis of a rich swath of empirical evidence, which Hedy himself talked about in terms of hundreds of texts, ranging from human rights reports to Israeli parliamentary debates and legal materials dealing with Palestinians in conflict with the law. The conceptual and analytical insights the book offers resonate strongly, not only across other contexts of political violence, and I had Kashmir in mind as I read his book, but also other domains where attempts to leverage children's rights, and I'm thinking of my own work in terms of child labor and poor and disadvantaged children, have often, with the backing of international humanitarian organizations, aided in maintaining and legitimizing contentious state actions. So at one level, Hedy's book reiterates what other scholars have discussed in terms of the porosity between the Israeli state's upholding of the law and its routinized rather than exceptional forms of violence. However, at another level, Hedy's focus is unique as his critical exploration of the entanglements between law, rights, and childhood is not limited to the Israeli state, but also extends to include its human rights critics. So in flagging the counterproductiveness of a children's rights focus, Hedy's book resonates strongly with post-colonial scholarship that has interrogated the violence, hierarchies, and ambiguities produced by liberal categories like rights. Their historicization of these categories often combines a critique of its decontextualized assurances embedded within more universal projects to save and reclaim lives. And Hedy's book is similarly invested in problematizing the self-evidence of childhood and the law. His efforts to destabilize the widely prevalent moral common sense on children in context of political violence draws on the tropes of age, developmentalist essentialism, and infantilization to disclose how these variously index modes of control directed at adult Palestinians and mostly Muslim Palestinian men. In my comments this afternoon, I want to focus on two aspects of Hedy's situated insights, namely the pitfalls of putting children first, and second, the normalization of uncertainty as a mode of governance. In my discussion of these broad points, I hope to open out Hedy's broader critique of the multiple quandaries presented by discourses, practices, and representations that rest on abstractions and generalizations regarding children and childhood and its material and symbolic effects. Knowing from my own research on child labor and schooling in the Indian context that everyday understandings of childhood always exceed and seldom fit neatly into abstract legal discourse, nor dominant humanitarian representations, I read Hedy's book deeply appreciative of his efforts to disturb this dense landscape. However, I also saw reflected in what I see as his advocacy around strengthening intergenerational relationalities, a reflection of these everyday understandings. And my comments are directed at distilling its specifics in light of Hedy's overarching problematization. So to the first aspect around the perils of putting children first, the ontological construction of the child as an apolitical and an innocent figure has been used to obfuscate, distort, suppress, as well as produce particular kinds of affective and subjective responses. Hedy's book resonates strongly with work done by childhood studies scholars who've explored the racialized, gendered, and class production of children as both at risk as well as the risk, with its related efforts to isolate children by highlighting their deservingness in relation to adults in their community. This defining of the interests of children separately from those of adults, and particularly parents, as scholars have shown across a range of colonial, post-colonial, and settler colonial settings, has neither helped children nor did it allow for the needs of children to trump the rights of parents, necessarily protect children. So Hedy's book adds to this landscape by unpacking how both the law and the child circulate as discursive technologies that are used to produce and maintain these normative boundaries. More blatantly, the Israeli state's leveraging of these boundaries, making and marking to legitimize its acts of routinized state violence. Hedy powerfully analyzes the tokenism of reform efforts, making known the gap between judicial practice and statutory Israeli law, and discusses the multiple forms of separation Israel imposes on Palestinians inside and outside of prison, all of which are directed at disrupting intergenerational relationalities, including the transfer of knowledge contained in these relational exchanges. Moreover, he further complicates this normative boundary setting by disclosing its parallel fluidity. This is namely the Israeli state's framing age of Palestinian young people, seldom as a fixed number, but as that which is constitutively elusive. This elusiveness of age brings to mind what Jasbir Puar's theorization of Israeli settler occupation as maiming, where, and I quote, maiming functions as slow but simultaneously intensive death-making. Hedy maps this in terms of Israeli state's open fire regulations, and to Puar's point on targeting to maim being, and again I quote, an accelerated assault on both bodily and infrastructural fronts. Hedy's analysis includes details on restrictions on the entry of food and movement, foregrounding the everyday working out of the right to maim and not the right to live as that which is being exercised as the domain of sovereignty. In this context of an Israeli biopolitics that normalizes the elusiveness of age, human rights organizations appear to want to achieve its inversion, namely reinstate the boundary-making capacities of the norm through generalizations that reinforce certain developmental and essentialist constructions of childhood. Hedy's book, however, argues that these efforts to defend the right of childhood or call attention to children's trauma by reinforcing the developmental status of the young person not only results in the further demonization of older Palestinians, but also perpetuates the image of the young Palestinian as primarily victims, thereby ignoring their accounts of the conflict with Israeli authorities as socially and politically empowering. Hedy is thus asking us to think differently in terms of the combined effects of the Israeli state and human rights organizations when it comes to the child and the law, by paying specific attention to how these jointly aid in curtailing intergenerational solidarity. While I do not want to foreclose the problematization that the book offers by posing the then what question, I wonder if Hedy could speak more to the tensions of how your powerful critical disaggregation of Israeli state's abusive elusiveness around age is also implicitly based on the normative boundary setting capacities of age and law. Can you speak more to the pragmatism of needing to work with boundary making, the potential of putting children first, in contexts where maiming, and I'm quoting Puar, masquerades as let live? Is this pragmatism necessarily foreclosed by the efforts of humanitarian and human rights organizations? And I would like you to speak a little bit, and I think Noura brought this up at the end, in terms of the differences of leveraging this boundary-making capacity between international humanitarian organizations, like the industrial complex, as opposed to local human rights organizations. And are there ways in which critical legal studies might theorize this pragmatism around age in context of settler occupation in a manner to what Habiba Ibrahim in her recent book, Black Age, discusses as Black age as a prism? For Ibrahim, and I quote, Black age as a prism through which the abuses of liberal humanist dispossession, as well as Black cultural, political, and historical reclamation are visible. And I wonder, in the context of Israeli occupation, where living and dying are in a zone of proximity, again, Puar using Berlant's idea of slow death, to what extent does intergenerational solidarity itself rely on the Palestinian people wanting to put children first by marking age through any means necessary, including legal means? For example, Palestinian parents and youth fighting their cases in the military court and appealing for their children to be considered as minors. Does this disclose intergenerational relationalities as messily relying on this boundary marking while also working with its tensions? Connected to this is my second point that Hedy makes around uncertainty as a mode of governance. Hedy explores this uncertainty in profoundly complex ways, including how earlier age-specific categories of youth, tender adult, and child was replaced by the terminology of a minor at the urging of human rights organization, and how Israel's military court's application of this category, which is formally not open to judicial discretion, has been anything but inconsistent. Yeah. It is this debilitating combination of vagueness, inconsistency, and control that renders youth both a mitigating and an aggravating factor, that instrumentalizes the physical appearance of young Palestinian defendants, and which marks the court's ambiguous enforcement of military legislation. Within this uncertainty, age does not protect, but rather circulates as a matter that determines who gets to live and who is spared death. Given this context of occupation where uncertainty is the dominant biopolitical temporality, I wondered whether childhood studies' emphasis on the being and not the becoming might need not to be simply inverted, but complicated in order to better attend to the future temporality that also seems to characterize Palestinian intergenerational relationalities and resistance. So, Hedy, from your brilliant analysis in the book, we know how the socially manufactured categories of child, law, and right get weaponized, instrumentalized, and detrimentally reinforced in the figure of the child as being. However, if we understand the Palestinian claim for belonging and intergenerational solidarity as also a claim for a future temporality that cherishes the becomingness of Palestinian youth, how might the problematization that you offer factor in this desire for a linear temporality while also holding in tension your excellent complicating of its essentialist and developmental assumptions around children? So to conclude, I read Hedy's efforts to displace the primacy of the child conceptualized as a subject of law. And this includes the ways in which this legalism is maintained through the child's difference from adults, as a move directed at reframing the child as a subject that requires a more situated ethico-epistemic relational lens of investigation. Palestinian intergenerational relationalities appear to be hinged on a more radical idea of care and futurity that does not necessarily eliminate the normative boundary making set in place by the legal child figure as much as politicize its shaping as that which would always exceed this legalism. Thank you.
Thank you very much, Sarada and Noura, for these provocative and fascinating comments to Hedy's work. I'm going to I'm going to read a few questions, and then I'm going to give the floor back to Hedy so that you can reply to some. I don't think you will have time to gather comments for all the questions that people are posing. So I'm going to start with a question by Caroline Wenther, who's a student in my human rights class, actually, who wonders whether punishing the youth, is there any indication that Israel may fear some kind of uprising similar to what we saw in the early 2010s in several countries in the region, right? Then Jenny, I might mispronounce this, how to Malki asked, what obstacles did you face while writing this book? And finally, Yushi Su asked, in connection to what Professor Noura Erakat was referring to in the context of the United States, whether we can put forward the proposition that the clear injustice perpetrated against Black children in the United States opened the window of opportunity to examine police protocol against Black and brown bodies. Likewise, whether the advocacy for HR 2590 plus the election of progressive champions in the House of Representatives has opened the window to talk about Palestine and with support and win supporters and make a play for the quote power in the streets that are waiting to be picked up. Hedy, there are plenty of questions here, and if there's time, I may add some, but I want to give you time to address not just the questions that folks have asked in the chat, but also some of the comments that both Noura and Sarada provided.
Thank you very much, everyone, for the questions. Thank you, Noura and Sarada, for the very, very thoughtful and thought-provoking and generous comments. We need probably 10 hours to discuss this, at least, if I'm being modest, and I won't be able to address all the questions you raised because many of them are questions I'm struggling with myself in my research beyond the context of childhood, so thinking about state violence and law, and also beyond the context of Palestine, so thinking about childhood and state violence. There are many broader issues here, so I'll just share some preliminary thoughts while trying to address some of the questions. So maybe I can connect what Yushu was asking, the third question you quoted, Jorge, with some of the points made by Noura and Sarada. So there's a question here about whether there's a potential in some of these strategies to expose violence against Black and brown bodies, I'm rephrasing, and to mobilize opposition and protest. And maybe I can link that to Noura's question, and maybe also Sarada's point about pragmatism and Noura's question about what's to gain from utilizing law. So there's a lot to unpack there. I'll say a bit about all of that because there's a common theme there to an extent. I focused in my introduction on the perils and pitfalls of law. I certainly think that law is not one thing. Law is flexible. That's part of law's power, as is the discourse of human rights. So law can certainly be mobilized sometimes to gain certain things. And I know, Noura, in your work, you've tried to think about how we can use law strategically. In some of my earlier work, my previous book, a co-authored book called The ABC of the OPT, I have a chapter there called Lawfare, in which I really focus on discussing the strength and potential, as well as the pitfalls of using law as lawfare, thinking about both state lawfare and counter-state lawfare. So using law as a weapon, the limitations and the potential of that. There certainly are some potentials. Sometimes they're completely unrelated to the legal purpose of a certain process. So sometimes the gain to be had is about, for example, forcing the state to expose certain information that previously was unknown due to having to expose it during the proceedings. And we're familiar with all of those litigation dilemmas far beyond Israel-Palestine. There's interesting scholarship in relation to Guantanamo, for example, and how if the military commissions there, the military tribunals are considered rigged, there's still something to be gained from litigation there. So some of the dilemmas and potential are similar. At the same time, I could list a very long list of potential gains. Okay, so that's just one example. At the same time, I think there are structural limitations to law as a field. Thinking, for example, about how when an issue becomes a legal issue, it becomes overly technical. So there's certain symbolic power that only certain people have when the discussion is framed legally. Certain people, by definition, are excluded from being able to make valid truth claims within that discourse once it's been framed as a legal discourse. And also law only has certain concepts, whereas other concepts are considered non-legal concepts. I can say more about that. I'm just hinting at some directions because there's so much to address here. So I'm being a bit cursory in my responses. In terms of the potential of exposing violence, and especially Noura, you mentioned the bills by Betty McCollum, and one of the audience members mentioned one of those bills. I actually critically analyzed those bills in chapter 5, specifically over a number of pages. One of the things I mentioned is that even strategically, there are questions to be asked there, because actually under US federal law, the US is already, in principle, even though maybe not in reality, the US is in principle not supposed to give any aid to countries that are perpetrate grave human rights violations. So in principle, the US supposedly, if Israel is doing that, and arguably it is, the US already under existing law is not supposed to give Israel any military or financial aid. We don't need additional bills that single out children in order to do that. But what these additional bills do, they implicitly potentially suggest that there is something unique about children. Otherwise, we could just re-invoke the existing federal law. And now I'm just talking from a purely strategic perspective. Again, I'm being a bit partial and cursory in my responses. There's so much more to say, and we could complicate all of these discussions further. I'm just trying to attend to the various points. Now, there was a question about obstacles while writing, and there was a question about maybe Israel has certain anxieties about the potential youth uprising.
And perhaps, Hedy, yeah, if I may, you may want to connect the question on the book. There's one additional question on what were the motivations? What motivated you to write the book?
We need another hour, don't we? Okay, I'll try my best, people. I'll try my best. Let's see how much I managed to do that. So I want to say a few things. I do want to attend to one, I think, crucial point that Noura raised, which was, what do Palestinians say? Because I think that's a key question. I do try in the book to quote as much as I can young Palestinians, for example, and to show how repeatedly their own agenda and their own priorities are not only different, but also sometimes contrary to what human rights actors are claiming to do on their behalf. So I think to that extent, I'm able to echo some Palestinian lived experiences. At the same time, I do have to be transparent and say that the main object of this book is not claiming to speak for Palestinians themselves, because I don't think I'm the best person to do that. So I try to be quite modest about my own positionality as, let's say, white. In the UK, I'm considered white other. Let's say white Jewish Israeli men. I'm not sure I'm the best person to do that, but I do have symbolic and political capital that allowed me to gain access to certain legal materials that I think many other people would not be able to expose. So I tried, that was part of my motivation in focusing on military judgments, for example, using my privilege to gain access to those legal materials. But that also was an obstacle. So there was a question here about obstacles. Even though I have law degrees, including a law degree from Israel, I was never taught about the military law, because part of the Israeli self-perception is that the Palestine and Israel, or the territories over there and Israel is over here, And there are two legal systems, whereas obviously what the book tries to show repeatedly, that the two are intertwined and that constructions of childhood and modes of state violence bleed across the boundaries and the borders. But one of the obstacles was that I had to self-teach. I had to teach myself military law. I was never taught it because it's conceived as external to Israeli military law, to Israeli law, which is a very problematic conception. And it was also very difficult to gain access to these materials. If I had more time, I could explain more how I managed to gain access to them, but it took a lot of time. And again, building on my capital and some networks that I have. I will say, and again, I'm not sure that I'm able within the time we have left. We have 1 minute left, I think, Jorge. Correct me if I'm wrong.
You can take a few minutes. You can take a few more minutes, Hedy.
Okay,
Hedy,
I'll take a couple of minutes. I don't want to
Great.
keep people too long, but I'll take a couple of minutes. There were broader questions raised here about human rights norms more broadly, which is something that Noura asked, and about boundaries more broadly, which is something that Sarada asked about. And I do see continuities and parallels here far beyond the context that the book focuses on, and I do try to at least allude to those, if not more than that, within the book. And Sarada, I'm thinking, for example, about your work on child labor, which supposedly is something very different to the context I'm talking about. But we know, Noura, thinking about what young Palestinians say, and then on the other hand, think about what working children say. If we actually attend to some of their expressed experiences and wishes, we have enough scholarship now to show why these experiences and voices are so crucial, but also why they're being ignored. So there are parallels there in terms of human rights norms, in terms of the voices of the young people who are supposedly the beneficiaries of some of these discourses. I'm kind of jumping from one topic to another because I'm trying to cover lots of ground here. So I'll just maybe conclude with a couple of questions that were raised by the audience members. Is there a fear about youth uprising? I think there is, to an extent, constant fear about that, which is intertwined and kind of interconnected with some other anxieties that the discussant mentioned. So Noura mentioned the existential demographic anxiety, for example. And if there's a perception that every Palestinian is either potentially or actually a security threat, then that lends itself to a constant fear of an uprising, or maybe a perception that there's already constantly an uprising in the making. And one of the things that chapter 6, I think, talks about is the role of preemption as a mode of state violence in trying to manage that. And what's interesting, I think, in thinking together about state violence and childhood is how central preemption as a mode of control is to both of these fields. So in childhood, there's this logic that the state needs to intervene from an early age, right? Before children grow astray, before they become risky or before they become at risk. And then when we think of state violence, if you think of counterterrorism, we know, especially post 9/11, but also previously, that there was a growing emphasis on preemption as a mode of managing perceived threats. So what's really fascinating is to think about these two fields together, childhood and state violence, and to think, Caroline, speaking to your question about the fear of an uprising, think about how the state needs to intervene before there are any real threats, and also think about what that preemption, what forms of threats and violence that actually creates and reproduces in the name of preempting and preventing violence. So maybe I should stop here.
That's fantastic, Hedy. I really appreciate this. There's just one more comment or question that someone has posted in the chat, Kimberly Legister asked whether there are other resources other than your book that would provide a broader understanding of your development and experience. So I guess this is for you, Hedy, but also Noura and Sarada, if you want to weigh in, that would be, you can just tell the audience if there are any other resources that you might like to share.
First of all, I would recommend Noura's and Sarada's work, depending on what you're asking about. Because as I mentioned when I started, I think the book tries to be in conversation with several broader debates that are being had now. So to the person asking this question, I would certainly recommend both of the discussants' work. There's a lot of valuable critical work being done on Palestine. I don't think I would do justice to it by naming a few people, but I would welcome anyone interested to email me, and I'll be happy to refer you to work. But certainly, I think if you're interested in critical work on Palestine, Noura's is certainly a good place to start and think through. And equally with childhood studies, Sarada's. I'm being perfectly honest in recommending their work. Yeah, I don't want to single out anyone. So I haven't been useful at all, but you're welcome to email me.
Sarada, Noura, any final remark that you'd like to share before we wrap up this session?
I wanted to say thank you. I also wrote to Sarada if she can send me her comments so I can read them and study them. And
sure, would you do the same, please?
Yes, indeed. And I was just going to say that, Hedy's notes and the is just a fabulous bibliography and cites, for example, one of my first introductions to military court systems, which was Lisa Hajjar's work. So I would, courting conflict. So for folks interested in reading, start with Hedy and then go into his notes.
Yeah, I would second that. I think definitely read the book. It's really worth reading. And the thing is, what's really nice about it is that it's very accessible. So I really appreciate that, because you're dealing with a lot of kind of theoretical material and you're dealing with a lot of empirical kind of analysis that you're doing, and you still make it extremely accessible. So thank you.
Thank you both. And thank you again to the author, Hedy Viterbo, for sharing your book and your experience and knowledge with all of us. On behalf of the Center for Transnational Law at Rutgers University, I'd like to thank everyone who has participated. Noura, you want to say something? Go ahead.
I want to say one thing on record. This wouldn't matter in any other forum, but just in case that I confused in my memory Dianne Feinstein with Barbara Boxer, this was not an accusation of ill faith in terms of the early 2000s, but I want to be on record that might not be true. Okay?
Well taken. Very good. You may follow us, the center, at ctl.rutgers.edu. We're also on Twitter, so you can be on our mailing list for upcoming events. Thank you again to the three of you. Stay tuned, be safe, and see you next time.